And our last case for today is Michigan AFSCME Council 25 versus Wayne County. This is a 15-minute mini oral argument on the application. Both have 2 minutes of a free fire zone, which you may waive. And if you are going to reserve time for rebuttal, we just ask that you keep track of your time. Ready?
May it please the court, Robert Federer and Miller Cohen, on behalf of Appellants, AFSCME Council 25, and its affiliated Local 101, and Victor Plessa. It is my intent to reserve a couple minutes for rebuttal. This matter presented before the court has a broad impact on labor relations in the state of Michigan in the public sector, and the rights of individual workers to seek reinstatement as part of a make-whole remedy, whether it be an arbitration or a lawsuit or civil rights action, whatever it may be. Because certainly if the Court of Appeals decision is left to stand, there's going to be an argument in many situations against employees that they do not have the right to reinstatement. In 1962, this court first adopted the standard of review for labor arbitration cases, and it was taken from the Supreme Court's seminal cases, which are referred to as the Steelworker Trilogy. That standard was again adopted in the Kaliva case in 1975. And this court specifically found that the standard in private sector labor relations under the NLRA is appropriate for the public sector under PARA in the state of Michigan. In Gavin in 1982, this court held that commercial arbitrations can be reviewed for legal error, which is inconsistent with the Steelworkers Trilogy and Kaliva at the time. The case did not indicate explicitly or implicitly that it was overruling prior labor arbitration cases or precedent. The standard under the Steelworker Trilogy is extremely deferential to labor arbitration, referred to as the narrowest review in all of American jurisprudence. Final and binding arbitration should be what it sounds like. Final and binding. It consists of essentially two standards: whether the arbitrator was acting within the jurisdiction granted by the parties, and whether the award draws its essence from the contract. It is not disputed here that the arbitrator had jurisdiction to hear a just cause dispute. Wayne County argued below, and the lower courts agreed, that the more broad standard under Gavin used for commercial arbitrations should be used in labor arbitration, which would allow a court to vacate a labor arbitration award for legal error. Now, this has a broad impact.
Counsel, I'd love to jump in. Let's assume I agree with you that Steelworkers Trilogy should apply longstanding labor law principles. What are we to do with the fact that there's this claim that what happened was essentially an unlawful resolution? And I understand you maybe disagree with that, but what if it is unlawful? Then I'm just wondering, what is the end result here? So would we remand to apply under the proper standard, but could we still end up in the same place?
No, I don't believe so. One possible outcome from this court is the remand under the appropriate standards, but we don't believe that that's necessary because A, there was no legal error. If there is a standard that's in the labor arbitration realm for arbitration awards that violate public policy, that has never been adopted by this court, but it's been adopted by the Court of Appeals, and it's been adopted by the U.S. Supreme Court in the private sector. But that requires a well-defined, dominant, expressed in statute, where the award is essentially illegal. And that didn't happen here. What happened here, allow me to address this for a moment, because they bring up this issue of the bona fide separation. And that argument that Wayne County makes regarding U.S. Code, and Brother Counsel will probably come up here and state it as a fact that that was violated. And it was not. That argument is completely bogus. Now, we can agree on some basic principles as to that issue. One is that generally a retirement plan cannot pay in-service benefits. We agree. There must be a bona fide separation of employment. When an employer and an employee intend to sever that employment, or do not intend to sever that employment relationship, there is not a bona fide separation. This has occurred and played out in guidance from the IRS in several ways. An employee moves from a union position to a management position. IRS says, no bona fide separation, you're still working there. I moved from a full-time position to a 20-hour-a-week position. The IRS says, you didn't sever the relationship. You move from a position covered under the pension plan to a position that's not covered under the pension plan. IRS says that's not a separation. There is no case that they have cited, or that we were able to find, that a bona fide separation does not exist when there's a contingency of pending litigation or arbitration. None. And further on, that was clarified in 2011 by the IRS, excuse me, when they issued IRS private letter ruling 2011-47038, where the IRS said, and quote, if both employer and employee know at the time of the retirement that the employee with reasonable certainty continues to perform services for the employer, a termination of employment has not occurred upon retirement and the employee is not legitimately retired. Therefore, they've adopted this reasonable certainty test. Certainly, the retirement disclaimer form that Mr. Plessa had signed was drafted around that rule. It asked whether you had some agreement with the employer that your employment wasn't going to end. And that's what the rules intended. Now, due to his retirement and his termination of employment, there is no doubt that he was not going to continue to perform services for Wayne County. He was fired, and he had retired the day before he was fired. So moreover, for there to be an issue, for the IRS to come in and have an issue with this, they would have to find that at the time of retirement, the employer and the employee knew with reasonable certainty that he would continue to perform services for the county. There is no chance of such a finding. The parties were disputing whether there was just cause for his termination. It was a close call. The arbitrator found that there was just cause for a suspension, but not just cause for a termination. Neither party knew with reasonable certainty that the arbitrator would reinstate him. Going one step further, under the plan documents for the retirement plan, there's a provision, section 3.2, that allows for reemployment. So let's take this in a slightly different context under the terms of the plan. Mr. Plessa retires, terminates his employment. 2 years later, the county says, hey, we need somebody that can operate this machinery. Can you come back for a couple years? And he says yes, and he comes back. The plan allows for that. But there can't be any prearranged agreement at the time of retirement that he's going to come back. If some contingency occurs or some decision is later made, there's no issue with a bona fide separation. So that was a very long way to get around to the question.
It's a complicated issue, so no, thank you.
But I believe that this court, because of that, can certainly enforce the arbitration award as written. Now, moreover, I think it's important to note, to follow up on that, what does the retirement system believe about this scenario? This is really a retirement system issue, not a Wayne County issue. They are separate entities. Nobody denies that. All the evidence suggests that the retirement system believes that this was a bona fide separation. Now, here's the evidence. The retirement system does not ask on the retirement form about possible reinstatement or whether you're seeking reinstatement through a grievance or through a lawsuit or any other means. It doesn't even ask if there's a pending grievance or lawsuit. At the time of the approved retirement, the grievance was filed. So when the retirement system granted the retirement, the grievance had already been filed. And they did not believe that it was in violation of some bona fide separation rule. In January of 2019, when he withdrew his funds and rolled them over into his personal IRA account, they approved it. The grievance was pending at that time, and the retirement system did not bring up the bona fide separation issue. The retirement system has never joined or submitted its opinion in any way in the arbitration or in this case, ever. It has not even filed an amicus brief before this court. Now, most importantly, in the time that Mr. Plessa had re-entered the plan, so when he came back to work for a period of time, which was between the arbitration award and the trial court's decision, it never sought repayment. Never. This is most notable. In Chavez versus Plumbers and Steamfitters Local 487 pension plan, 612 F sub 3D 516, and the cases it cites regarding bona fide separation, in each instance, the retirement plan learned of a lack of a bona fide separation and took action, usually to recover the payments that were made. That didn't happen here. Moreover, even though there was not a bona fide separation, or even if there was not a bona fide separation, that would be the remedy. The remedy would be to seek repayment of the funds, not to limit the just cause provisions of the collective bargaining agreement. The county has completely manufactured this legal issue. It is not an issue that would warrant vacating an arbitration award in any instance. And I do want to point out just a brief history here. The Kaliva Court, again, was decided in 1975. 1982 came Gavin. 1986, this court decided the Port Huron case, which was another labor arbitration case. It made no mention of Gavin. It did not assert after Gavin, this court did not assert after Gavin, that Gavin had changed Kaliva and the reliance on the Steelworker Trilogy. Then, and perhaps even more tellingly, in two cases, two commercial arbitration cases, parties in those cases asserted that the labor arbitration rules and precedent apply to commercial arbitration. That happened in Beck in 2016 and happened in Lacan in 2021. This court, on both occasions, said that labor arbitration rules and precedent do not apply to commercial arbitration. Then the Court of Appeals in this case, for the first time, applies directly Gavin and the commercial arbitration precedent to a labor arbitration case. Now, labor arbitration and commercial arbitration are very different. And one is based on a substitute for litigation, which is commercial arbitration. One is an extension of statutory obligation to bargain, which is labor arbitration. And I direct the court to the brief of the National Arbitration Association, co-authored by Ted St. Antoine, who's a legend in Michigan arbitration, has been cited by this court in previous cases as an authority in labor arbitration. I have some time left I'd like to reserve for rebuttal, unless there's any other questions. Thank you.
May it please the court, Bruce Campbell on behalf of the Appellee, Wayne County. Before I get into my prepared remarks and I waive my 2 minutes, I'd like to address something that came up during Mr. Fetter's oral argument that I think is incorrect. The arbitration award essentially revoked the termination. So at the time the arbitration award was entered, and as long as it would be enforceable, there actually was no termination. There was no separation of service. And so what you have is, you have an individual who, without a termination, got full access and withdrew his entire retirement account. Now, Mr. Fetter is correct that the retirement system could go after those if he's returned, but instead, the county decided to go and to move to vacate the award. So the second thing is, Mr. Fetter seems to agree that there is a requirement that the separation be a bona fide separation. Well, the fact that they filed a grievance indicates that the union, and presumptively Mr. Plessa, did not believe it was a bona fide separation. And the bona fide separation waiver says, I'm terminating my employment. It actually says, you, meaning the person who's signing it and initialing it. And I have no offer, promise, or agreement, orally or in writing, concerning reemployment. But they were relying on an agreement that would allow him not to just become reemployed, but actually never to be terminated. And so there was that was a clear violation of two things. One, the bona fide separation rule, and number two, it was a violation of the in-service distribution rule. And unfortunately,
Mr. Campbell, as I understand your position, Plessa could not have filed a grievance because he retired? Is that basically your position?
Not exactly, Justice Zara. I think there was legitimately within the jurisdiction of the arbitrator approximately a 5 to maybe 6 week period from the date Mr. Plessa was discharged to the date of his retirement. And had the arbitrator found that there was no just cause for the termination, discharge, and he had found, that no suspension was warranted, then, the county would have been obligated to pay the back pay for that 5 week period. Because the arbitrator reduced it to a 90-day suspension, that 5 to 6 week period wasn't at issue. So did it bar the grievance in total? No, it did not. But it barred the remedy that the arbitrator issued. As this court has acknowledged in providing us supplemental questions, realistically, it was in 1986 that this court issued 2 decisions over a 2-term period. And those decisions were in the Bay City case and the Port Huron case. And we submit that these cases define the proper scope of judicial review of public sector arbitration awards. These decisions were well-reasoned, and appellants have failed to demonstrate how the Court of Appeals decision in this case is contrary to those decisions, nor have they presented any persuasive arguments or any arguments that either of those decisions should be overturned by this court. First, the Bay City case. And as mentioned earlier by Brother Counsel, there's basically 2 ways you can overturn potentially an arbitration award. One is there a violation of law or public policy? Bay City addressed that aspect. And it stated, citing Gavin, that an arbitration award would be invalid if it violated a judicial decision or some other type of law. Then in the next term, the Supreme Court decided the Port Huron case. And the Port Huron case addressed the contract aspect of this. It didn't address the violations of law. And in that instance, this court vacated an arbitration award. And in that case, they cited steelworkers, and they recognized that there was considerable deference to arbitration awards. However, they distinguished in a very particular way that an arbitrator who acts beyond the scope of his jurisdiction is subject to having that award vacated. And in that particular case, the starting point is, what does the arbitration agreement say? And in this case, it says, an arbitrator shall have no authority to amend, alter, or modify this agreement. Further, the arbitrator shall limit his decision strictly to the interpretation, application, or enforcement of this agreement, and shall be without authority to make any decision contrary to, or inconsistent with, or modifying, or varying in any way the terms of the agreement. So the contract, the result of painstaking collective bargaining, negotiation, and agreement limited the authority of the arbitrator. And in this particular case, there was a bona fide separation waiver that Mr. Plessa signed at the time of retirement. If you look at the collective bargaining agreement, there's a retirement provision. And the retirement provision says that the retirement ordinance shall control. So it controls over any other aspect of the collective bargaining agreement. Now, within that, it says that there are certain things that can be changed, and they outline those, but those aren't relevant here. So for purposes of this decision, the retirement ordinance controls. Then the retirement ordinance, and we cite this in our brief, says that the board shall set up the requirements for being able to retire. And it specifically says it intends to follow the tax code and all other applicable laws, and has plenary authority, to act on in order to exact compliance. So as a result of that, you have this bona fide separation waiver that's essentially part of the retirement provisions of the contract. And the arbitrator ignored them. He said he thought that he only did it because he thought he was going to be fired. Well, that may or may not be so, but he signed a paper saying he was terminating his employment. And the arbitrator said, well, the agreement, the bona fide separation waiver didn't say anything about the grievance procedure in the collective bargaining agreement, except that the waiver said, and there's no agreement concerning reemployment. There's not any agreement. That's as broad as you can make it. And so when you consider the scope of the arbitration and the authority there, and you look at what the arbitrator did, he clearly acted outside of his authority. And we point out in our brief, the case that this court cited was a district court case out of the Northern District of Ohio, and it was a U.S. Postal Service case. And I believe that citation was important, not just because for what that case says, but why that case was cited. And that is, this is public sector arbitration. And public sector considerations are different than private sector considerations. And so, in the way this court has always interpreted steelworkers is through that lens of public sector viewpoint. And that's why it's different than some of the private sector cases. We cite a case out of the Federal Labor Relations Authority. How does the federal government, deal with its own employees and arbitration? And they have, without citing Port Huron or Gavin, they essentially have the same standards that are in Port Huron, and that the Court of Appeals, in a very well-reasoned opinion, went through it as to how the arbitrator exceeded his authority. Unfortunately, for something like tax compliance, and I want to let the court know, when we've brought this, not just before this court, but below, we had all these vetted by tax counsel to make sure, we were providing the most accurate information and analysis that exist. So, and unfortunately, penalties under the Internal Revenue Code are draconian. So, this is, vacating this award Doesn't just help the county, it helps the retirement system, it helps everyone who's a participant in the DC plan. Because remember, this arbitration award, if it's enforced, it becomes the contractual basis. So there's no contractual bar for this to come up in any other situation. Also, the situation that's here, where you have somebody nearing retirement who faces potential, who faces some potential discharge and wants to essentially take advantage of retirement in one instance and then take advantage of a grievance procedure to thwart discharge, that could happen to any local government anywhere throughout the state. So, from our perspective, we see this as a very serious matter. The arguments that have been presented are by the appellants and by the amici. The amici focus on the private sector. They don't describe it, they don't say anything about the public sector, they don't say anything about the tax code. There's no real analysis in the appellant's brief about the tax code. They just say, well, this really doesn't exist. Very briefly, I want to address the whole idea, well, why wasn't the retirement system involved in the arbitration? Well, that's clear. The arbitration, the CBA, is between the county and the union. It's not between the retirement system. The retirement system is the county's plan administrator. I mean, that's clear. So they didn't need to be a party.
But they could have sought reimbursement, right? Is there a process to do that?
Well, they didn't need to, because that would have awaited whether or not the arbitration award was vacated or not. If ultimately it's enforced, then I believe, based on the case law I've seen, particularly the Metzger case, that the retirement system would be obliged to seek reimbursement for those funds. So, but basically, the county, brought its motion and its complaint to vacate the award, and so they were going to await whatever happened there. There may have been no need for them to file any lawsuit.
I have to, I find this very complicated. We've got two very competing viewpoints on sort of what the impact could be on the pension fund, which of course goes to potentially the public policy piece. So I am trying to figure out if we have enough before us to address this, because it feels like there's a lot of unknowns.
Well, here's what's, and just to let you know, this idea that this could become a problem, during the time that this litigation was ongoing, the IRS was doing an audit at the retirement system, not on this particular item, but the IRS does audit systems. So, because of one person, would they tax disqualify? Again, I don't know the answer to that question. However, I do know this: it's a violation, and the violation would have to stop, and there'd have to be corrective action taken. But the problem is, when you got an award saying, no, you're contractually obligated to do this, how do you address that? And hence the need to vacate the award. If I could disagree slightly with your characterization, and that is, you've only gotten arguments really from one side on the tax issue, and that's from us. 7 briefs have been filed between amici and the appellants, and there's been no substantive analysis or counter analysis or anything, citation to authority. And thank you for your time.
Thank you.
Brief rebuttal.
And I'm going to start real quick. So what is your response to what I would call the have your cake and eat it too argument, where you can't, that we just heard, you can't file for retirement and then turn around and use the grievance process? That you're double dipping.
Yeah, I think that happens often in the labor context where an employee who believes that they may be soon terminated, who are eligible for retirement, and a termination may jeopardize their retirement benefits, they file for retirement, which does not, usually it's up to the arbitrator as to whether they've waived any rights by that retirement. This arbitrator found that he did not waive any rights. Waiver is a question of fact. Questions of fact, by any standard, are not reviewable in court. There's quite various issues of fact that Wayne County has presented, including whether there is a waiver, including whether he would have or intended to, based on the testimony and the evidence, if he was not terminated the next day, whether he would have clawed back his retirement application, which had not been approved yet. That was a question of fact found by the arbitrator in issuing a make-whole remedy. Now, I think if you parse through what the county said, it resolves this case. He cites the Metzger. Metzger says that when there was not a bona fide separation, it was resolved any IRS issues by just asking the employee to refund the money. So that resolves the case. It was up to the retirement system to seek the money back if they think it was a bona fide separation. Then there is no IRS issue whatsoever. And certainly you can't vacate the arbitration and limit the just cause that's been bargained for in the collective bargaining agreement based on the inaction of the retirement system. If there's no other questions, I see that my time has expired.
Thank you.
Thank
Thank
you.
you both. The case will be submitted and the court is adjourned.
Thank you.